Once the state and the appellate get their briefs in, it's then going to go to that Court of Appeals to render a decision. As far as timeline goes, the best answer I've ever seen is that the only answer you will get from a Court of Appeals quickly is the one that you typically don't want. They take their time, they review it, their procedure and their goings-on at the court are very insular and are not really generally known to the public. They won't tell you the status of the case if you call them, so don't really bother. What you need to do is just sit back and wait for that opinion to drop. And once that opinion is received, it's very important that you review it and you make a determination as to whether or not you think they made any errors in their issuance of their opinion. Because you have a couple other deadlines that come up after that. The first is a motion for rehearing. That needs to be filed within 15 days. If this is meant to capture perhaps maybe there was a change in the law between the time that you submitted your briefs and the time that the Court of Appeals decision came down. Or perhaps the Court of Appeals decision came down and on the same day another court, hopefully a higher court, came down with a decision that was completely contra to whatever the Court of Appeals is saying. Those are the best grounds for a motion for rehearing. And you're going to need to swear that this is not for the purpose of delay, so you want to make sure that you've got really good grounds before you file this motion for rehearing. Now, 15 days obviously is not a lot of time, and so the Courts of Appeals, being understanding of that, will allow you to file an extension on that, but you have to file it within that first 15 days, and they're not really going to give you a huge amount of time to make it right. You might be able to get them to give you a full 45 days in order to get your motion for rehearing, but you don't really want to press them too much because it's not something that you're entitled to as a matter of right. Anything that you're not entitled to as a matter of right, those deadlines become much more stringent and much more difficult to deal with. Assuming that you have something, you file that motion for rehearing. The court can decide whether or not they want to grant that, whether or not they want to change their opinion. They're not required to. If they do not, or if you decide not to file the motion for rehearing, the next avenue of relief is what's called a PDR. This stands for Petition for Discretionary Review. The Court of Criminal Appeals is the court that handles this. They are the highest criminal court in Texas. And unfortunately, you don't have an appeal to them as a matter of right. Discretionary is right there in the title, and you need to keep that in mind when contemplating this. A lot of times, they refuse these PDRs, and they only accept the cases that they want to hear. The last statistic that I heard was during a CLE with some of the justices back in about 2016, and they were discussing 2014's numbers. If I remember correctly, they had received about 4,000 to 5,000 PDRs. They had taken up 200 to 300 cases. It's like filing a writ of certiorari with the United States Supreme Court. They don't have to hear you. They're going to take the cases that they feel need to be resolved, that have conflicts in the law. They're not really going to be looking at specific factual issues. They're really going to be looking at big picture stuff. So when you're drafting that PDR, you want to make sure you've got a really good issue and you want to put your best foot forward. But when you're trying to file it, keep in mind that you only have 30 days from the last decision at the Court of Appeals. That's either the opinion or the result of the motion for rehearing. That is a very hard 30-day deadline. They will not extend it if you don't file the motion to extend, which has to be done within the first 15 days. If you file it on the 16th day, they are going to deny it, and you are going to have 14 days in which to get this PDR drafted, edited, and filed with the court. So you want to make sure that if you're at all contemplating it, you file it as quickly as you can, or if you're doing the motion for rehearing, you're working on your PDR while you're getting it ready, okay? Now, once you go up to the Court of Criminal Appeals, like I said, they're not required to hear your case. They will take up the ones they want to, but the vast majority of them are going to be refused. If your case is taken up, they will issue a new cause number. It's an AP number, and they will hear your case. They will typically order further briefing, and that will give you a chance to kind of draft out your full argument, because there are some page limitations on the PDR. So you may be able to add some more, argue it a little bit more thoroughly, add in other issues that weren't necessarily there on the PDR. On that, it's kind of the same timeline. The appellant or the losing party has the right to file the PDR. If it's taken up, they will file their first brief. It will then switch over to the state in order to get their briefs in. Once their briefs are in, they may take you up for oral argument. It's really all at their discretion. And again, as far as a answer goes and a timeline on that answer, the only thing you're going to get back quickly is the one you don't want. A lot of times, if they decide that the case is not really ready to be resolved, or the issue isn't quite what they thought, they will dismiss your case as improvidently granted. This effectively just ends it without actually reaching any of the underlying issues. Now, once your PDR is resolved either by a full hearing or a refusal, you've got a couple of options. The first is always a writ of certiorari to the United States Supreme Court. You're going to need some really good constitutional issues on that, because the Supreme Court is not going to touch anything that deals exclusively with Texas law. They're going to be focused a lot more on, is Texas operating in line with the United States Constitution through the 14th Amendment as it is required to do. If they don't feel that it rises to that level, they are not going to hear your case. You have exactly 90 days from the date of the result of the PDR, whether it's an opinion or a refusal, in which to file that writ of certiorari. And keep in mind that just the filing of that can get very expensive, because the requirements of the United States Supreme Court are often include an actual bound writ that's got a nice leather cover. They're not really going to be very happy with you just going down to Office Depot and having them put the little binders on there that you can get there. They're going to want something that looks very professionally done. As a matter of fact, there is a whole separate bar of attorneys that do nothing but deal with the United States Supreme Court, and they can be some of the highest profile and most expensive attorneys you can afford. But if you decide not to go that route, your next step is oftentimes to look at a writ of habeas corpus.